landscape, managing risks and opportunities. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with the question mark icon, or clicking on the ON24 support team link in the resource list. A copy of today's presentation slides are available also in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. If you are requesting CLE credit, please send an email to me, Jackie Polson, at jpolson@foley.com. That's JPOLSON. To be eligible for CLE, you will need to log on to both the ON24 session and answer a polling question during today's presentation. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during today's program. A 4-digit code will be announced during the presentation. Please email this form to me, again, at jpolson@foley.com. The form can be found in the resource list as well as the presentation and some other materials that we have provided for you today. With that, I will then turn it over to our host, Francisco Cerezo.
Good afternoon, Jackie. Thank you for that introduction, and thank you everyone for joining us. I guess let's start by making a quick overview of who will be today's presenters, and then we'll dive right in. When we first learned that these changes were coming in December, we immediately had significant contact from clients and friends everywhere from Latin America, the United States, Europe, and Asia. So we immediately thought that we would put together a team at the firm that would act as a task force to lead the firm's efforts in helping our clients understand the changes that present obviously a number of opportunities but also come with risk. To that end, we have 3 terrific resources at the firm who will be the main speakers in today's webinar. And in order, as they appear on your screen, they're Greg Husisian. Greg chairs our export control and national security practice out of D.C. He's an expert in the field. He's actually the author of the leading treatise in U.S. regulations on import-export published by Thomson West. And he also is the author of an excellent, a very comprehensive compliance guide to doing business in Latin America, which will also be available for the participants to download and to view online on Foley.com, and you'll learn more about that towards the end of the presentation. Greg has very significant substantive experience on how the regs work, having been a thought leader in this area for a number of years. Christopher Swift, also from our Washington, D.C. office, is another key member of our Cuba team. Christopher is not only extremely well-versed on all these issues, he has the very unique characteristic that he was actually, in a prior life, an enforcement officer at OFAC. So issues such as the ones that companies will be facing are exactly the type of issues that Christopher had to address while he was at OFAC as an enforcement officer. So his perspective is extremely valuable and unique. And then last but not least, we also have Lauren Valiente. Lauren is a member of our government enforcement team, and in addition to that being the only Cuban-American among the 4 presenters, including me, in addition to that distinction of being Cuban-American, Lauren has been very involved in matters related to Cuba for a number of years, establishing herself as a thought leader not only in the Cuban-American community but in the broader business and legal community, especially as it pertains to Florida. So we're happy to have Lauren participate as well and present. when all of this started, let's see, go to slide here. Apologies, there we go. Okay. I think I may have an issue with a slide, but we just had some key dates. There we go. So December 2014 is when the president announced his intention to ease the 54-year-old embargo. And I think by that afternoon, each of Greg, Christopher, Lauren, and my phone had just started ringing off the hook, both from colleagues at the firm and from clients. But at the time, all we knew that was the intention of what was coming, but there really wasn't much by way of substantive disclosure of what was going to be taking place in terms of changes in OFAC at the Treasury Department until in January it was announced that the Treasury Department would issue the new regs. Indeed, the regs were then published on January 16th, and that allowed the lawyers, the bankers, and everyone else interested in the subject matter to really get into the nitty-gritty and understand in a more nuanced what exactly were the opportunities in Cuba. I apologize for everyone. My internet connection is not that great. Okay. Turns out that the opportunities, as what is announced initially by the president, and then was as evidenced by the revised regs, are primarily in several areas. One is banking and financial services. The other one is travel and tourism, telecoms and consumer electronics, private entrepreneurs, private residential construction, agricultural equipment for private farmers, and then lastly for multinational corporations. In terms of multinational corporations, that applies not only to U.S.-based multinational corporations, but as for a number of the participants on today's call calling from throughout Latin America, it also impacts Latin American multilatinas that were, while their home countries did not have any direct restrictions in doing business with Cuba, because they had a substantial U.S. nexus, whether they were companies from Colombia, Mexico, Dominican Republic, or elsewhere, because they had a significant operation in the United States, had a sufficient nexus that they were also then subject to the U.S. regulations, just as if they were a U.S. company based in the United States. So with the opening of these new sectors, mostly driven by public policy considerations of the U.S. to try to ultimately lead to a wholesale lifting of the embargo, we decided we put this presentation together. We made a point of not turning this into any sort of partisan discussion on the policy considerations behind whether it was appropriate to ease the sanctions and whether folks are in favor of lifting the embargo or not. The purpose of this webinar is ultimately just to walk our contacts, our friends, our clients throughout Latin America into what are the facts and what to avoid, where the opportunities are, and not into any sort of public policy discussion on the merits of the president's announcement in December and the recent actions. So with that said, I will cede the word to Greg Husisian, who will then start discussing specific opportunities and the regs, generally how they work in Cuba, followed by Christopher and Lauren.
Okay, thank you, Francisco. I'm actually going to be on here twice because we're going to talk both about how the operation of the sanctions work, and then Christopher is going to talk about how the sanctions have been, the easing has occurred, and how the opportunities in Cuba have expanded greatly in the last couple months. And then we're going to return to the topic of compliance, which we find is one of the areas where the clients have the most issues because they want to be careful not to go too far and to get into trouble, given how big the penalties can be in this area. So for the people who have not been that familiar with the sanctions, they're administered by the Office of Foreign Assets Control, or as it's affectionately known, OFAC, within the Department of Treasury. The restrictions with regard to Cuba are restrictions on basically how U.S. persons can do business with Cuba, and also our controls over the use of the U.S. financial system. There's a number of OFAC sanctions that are in place. Some are based on countries, They're aimed at countries and with dealings with that country. Others are aimed at governments. And then the third kinds are aimed at basically at the bad guys, people who've taken activities that are contrary to U.S. foreign policy. In general, the OFAC sanctions that are based on countries, the ones that are comprehensive, are the strictest regimes, and Cuba has always been one of the strictest regimes, along with the sanctions that are against Iran and that are against Sudan. To show you how seriously OFAC takes this area, we've seen penalties as high as $8.9 billion, of which a significant component was related to the OFAC sanctions. This is an area where the U.S. government has a lot of enforcement resources that are aimed and where the U.S. government takes it very seriously. So understanding exactly what you can and cannot do under the sanctions is critical. Now, one thing that often will trip people up is they don't realize just how expansive sanctions are. They apply not only to actions that are taken within the United States, but to any actions taken by U.S. citizens or permanent residents wherever they're located. It covers any entities that are organized under the laws of the United States, such as a corporation. And the Cuba sanctions are unique in that they extend even to separately incorporated subsidiaries of U.S. companies. So the intentional reach of the sanctions is as broad as possible. OFAC even will go so far as to say if a transaction, the payment for it, has hit the U.S. financial system, then that gives them jurisdiction over the area as well. So as you can see, this is something that's viewed as being very expansive because OFAC is trying to regulate as much activity with regard to sanctioned countries as it can. Now, people will sometimes say, what exactly are involved with regard to the Cuban sanctions or other sanctions? And with regard to Cuba, the answer is very simple. You're not supposed to be dealing in trading goods or providing financial or other kinds of services or indeed having any kind of transaction or even travel with regard to Cuba. The only exceptions are ones where OFAC has sat down and said, these are categories where we are not going to assert the full reach of the regulations. But the operating assumption under the Cuban sanctions is if it's trade with Cuba or with the Cuban government or with a Cuban national who's ordinarily resident in Cuba, then you need to look and find that there's a license that's out there that will allow that to occur. Otherwise, the assumption should be I can't engage in this transaction at all. A further issue that comes up with regard to the Cuba sanctions that you don't find with most of the other sanctions is they've actually been codified by Congress. What that means is there's very strict limits on how far OFAC can go to change or lift the sanctions without Congress getting involved. And as Christopher is going to be talking about in a little while, that complicates the calculus because companies or persons who are looking to deal with Cuba don't know how far the easing is going to go and at what stage Congress might step in and say, no, we think you're going too far or you're making changes of which we don't approve. One other thing to keep in mind with regard to the Cuba sanctions is they not only prohibit dealings with Cuban persons or with the Cuban government or with Cuba in general, but they also include things that could be construed as facilitation. So, for example, if you're providing insurance services that would allow a transaction to go forward, that is going to be forbidden to the same extent that the underlying transaction is. So even providing support activities for transactions that are occurring with regard to Cuba or the Cuban economy can get you into trouble. So that's kind of the overview on the sanctions. They prohibit all sorts of dealings with them. There have historically been very few limited licenses that are out there that go to things like agricultural goods, medical supplies, very limited kinds of travel that have been authorized. But all that changed, as Francisco said, beginning in January when we saw what is the start of what could be a dramatic easing of the sanctions. Even though there's a lot of questions that are out there, it's still very exciting because the scope of the sanctions potentially is going to grow over time, and that's what Christopher is going to talk about. So do you want to take over, Christopher?
Thank you, Greg. Good afternoon, everyone. Thank you for joining us today. My role in this presentation is to walk through some of the new opportunities we're seeing under the eased Cuban asset control regulations and, to the extent that it matters, the Export Administration regulations, and also to describe sort of the policy context and the relationship between the executive branch and Congress on this issue as it moves forward. I like to say at the outset here that the guidance we're giving you on the easing in this webinar is really designed to give you a sense of the different areas where these opportunities crop up. It's when you get to the details that you need more specific guidance from a lawyer. So if you have specific questions about any of these particular areas, please feel free to give any one of the four of us on this call a ring and walk through those issues. Again, the general rule is what we'll be presenting here, but the specific application to your company, your business, your strategic plan may be a little bit different. So with that in mind, let's get into the core areas here. Let's see, slide. There we go, slide. So there are basically five major areas where the sanctions are easing and where opportunities for U.S. businesses are growing. And arguably the most important of those areas is banking and financial services. And under the ease sanctions, U.S. banks and other financial institutions can now finally open correspondent accounts at Cuban financial institutions. And that means they can process wire payments back and forth directly without having to go through a third-party bank in a foreign country. It also means that U.S. banks and other financial services companies can establish the sort of payment networks that allow U.S. credit cards and debit cards to be used in Cuba. Essentially, that means that anybody who's in Cuba for an authorized purpose, or anyone conducting business in Cuba for an authorized purpose on a business trip, an educational exchange, or otherwise, will be able to use a U.S. credit card or U.S. debit card, provided your credit or debit card provider has set up those relationships in Cuba. It's also important to note that U.S. banks can now provide certain financial services to Cuban nationals that are living outside the United States. There's an important caveat there, though. If that particular individual appears on OFAC's list of specially designated nationals, that is to say they appear on the blacklist, you can't do business with them under the easing of the sanctions. That's something that's going to apply sort of to all of the easings that we'll be talking about in my short presentation this afternoon. If they're still on the blacklist, you can't do business with them, even though the general rule may be in favor of easing. Finally, U.S. banks can provide certain financial services to Cuban government agencies that are engaged in official business here in the United States. There's been some controversy about that in the press in recent weeks, but the rule in the revised regulations is pretty clear. And significantly, U.S. insurance companies, which are also part of the financial services industry, can issue policies and pay claims related to travel and medical care in Cuba. It used to be that if you issued a global insurance policy, you had to specifically exclude Cuba from its coverage, or you ran afoul of the Cuban sanctions. Now that is no longer the case. You can indeed issue a global policy that is going to cover Cuba. It can't cover Iran and Sudan, however. It still needs to exclude those two comprehensively sanctioned countries. Otherwise, the policy is in violation of U.S. sanctions. Next slide here. The second important area is agriculture and construction, and also to a certain degree small business. Under the Export Administration regulations and the eased Cuba sanctions, there is a new license exception, SCP, that's support for the Cuban people. And essentially what it does is it allows the export of various U.S. origin products directly from the United States to Cuba to serve certain types of Cuban entities. And that's the breakdown is as follows: tools, equipment, and construction materials for building or repairing private residences. not for stuff that's owned or controlled by the Cuban government. Tools, equipment, instruments, and supplies for entrepreneurs that own and operate private businesses. Again, not for things that are owned or controlled by the Cuban government or by SDNs. And then agricultural equipment, machines, and supplies for use on private and or family farms. Once again, the support is for independent Cuban people, not for people that are operating through or with or on behalf of a Cuban government entity. It's also important to note that those of your companies that are already exporting to Cuba under a Trade Sanctions Reform Act or TSRA license that allows agricultural or medical exports can now make direct payments to Cuba thanks to some of the easing in the banking and financial services sector that I just discussed a few minutes ago. So direct payments are now possible under a TSRA license. Previously, you had to go to a third-party country in order to process those payments. Now it can go direct from the United States to Cuba. Next slide here. All right, telecommunications is another area where there's been a tremendous amount of expansion, at least on the U.S. side. Telecoms providers may now establish commercial cable and satellite and other linkages in Cuba that provide voice, data, television, internet, and the rest. That includes entering into contracts with third-party providers in foreign countries that may already be providing these services inside Cuba. It also allows information technology companies to export email, social networking, web browsing, and file sharing, and other sorts of similar telecommunications software to Cuba. You can do it directly from U.S. territory to someone downloading that software in Cuba. It also allows manufacturers to export certain types of consumer electronic devices like mobile telephones, personal computers, anything you'd use to get on the internet. The goal here is essentially to connect the Cuban people to the wider world and for U.S. telecommunications, information technology, and electronics manufacturers to help facilitate that process. As Lauren will describe in a few minutes, the realities on the ground in Cuba may hamper some of those efforts, but insofar as U.S. policy is concerned, the goal is to help the ordinary Cuban get online and tweet, chat, text, surf, and everything else that my teenage daughter seems to be obsessed with. Next slide here. All right, another big area is travel and tourism. We've seen a tremendous amount of expansion in this area during the course of the Obama administration. They've now codified those prior expansions into 12 distinct categories of authorized travel. It's everything from humanitarian, religious, and journalistic exchanges to educational exchanges, to anything that might involve normal business activities under the newly authorized areas that we described earlier. So if you're exporting to Cuba under license exception SCP, it would be appropriate for you to travel to Cuba in order to meet with a private entrepreneur that would be buying your material. One of the best things about the new regime is that these general licenses do not require any sort of prior authorization from OFAC. You basically buy your plane ticket and go. And travel providers and airlines can provide those services to you without prior authorization as well. Now, that being said, it's important to note that you need to fall within one of those 12 categories. And if you don't fall within one of those 12 categories and can't substantiate the fact that you fall into one of those 12 categories, then the travel is going to be prohibited. It's not clear yet exactly who will be policing that. It looks at the moment like that policing will be done by the individuals who will be traveling and also perhaps by travel agents and airlines. But in any event, when you're in Cuba, be sure that your program is directly focused on the purpose that authorized you to go. So if you're going for business activities and you're going to be there for 7 days, that's probably 7 days of working meetings. It's not 3 days of working meetings and 4 days of tourism. The reason being that tourism is still strictly prohibited, notwithstanding the easing in so many other areas. Also important to note that some of the changes allow limited imports of Cuban origin cigars and rum for personal use. My recommendation is read those regulations very carefully. That's one of these things that we enforced, perhaps over-enforced when I was at OFAC, mainly because we wanted to, people to comply with the law. But this is one of those areas where, it's possible for people to go off the deep end with some of the novelties. Moving on into the next slide. All right, the last big area to note here is some of the implications for multinational corporations. Francisco raised some of these issues earlier, and Greg very carefully explained all of the different ways that non-U.S. companies can become subject to U.S. jurisdiction. One of the big changes here is that some U.S.-owned companies overseas, some foreign subsidiaries and affiliates of U.S. companies, can now provide certain types of services to Cuban nationals that are living abroad. So if you have a company in Spain and you have a Cuban national come into your Spanish subsidiary, and that Cuban national is a legal permanent resident in Spain, it's now possible to provide that individual with some services, not all, whereas previously it would have been completely forbidden. There's also some easing of restrictions on vessels that travel to Cuba and then subsequently travel to the United States immediately afterward. Part of the goal there is to open up some of that exporting activity that we were talking about earlier. We also see a general climate that's moving towards, but does not necessarily guarantee, reduced sanctions compliance risk for multinational companies that are subject to jurisdiction both in the United States and in Cuba. Again, that's mainly going to be in the financial sector, the telecommunications sector, and companies engaged in the newly authorized patterns of export. And finally, it's important to note that many of the extraterritorial sanctions, or so-called secondary sanctions, that Greg and Francisco described earlier that affect companies outside the United States still remain in place, and that's because the sanctions don't undermine or take away the extraterritorial elements of the 1996 Helms-Burton Act. With that, I just want to spend a couple short slides talking about related transactions and then some of the policy trends. Related transactions are those that are ordinarily incident to everything that's authorized now. So if it is necessary for you to purchase a plane ticket or make a payment to, a Cuban hotel or eat out at a Cuban restaurant, any of those activities that might be ordinarily incident to authorized travel or authorized business activities is also authorized. The best way to think about that is if your activity is necessary in order to engage in what the U.S. government has authorized, then it's probably ordinarily incident. Also important to note that there have long been special rules for protecting intellectual property in Cuba, including even making an appearance before a Cuban court or making payments to Cuban government agencies in order to register or protect copyright, trademarks, and patents. That's something we can get into greater detail offline if need be. Some of the big policy issues to note here. The Obama administration has eased sanctions in 3 countries since coming to office. The first was in Libya with the start of the Libyan civil war. They put very strong sanctions on the books, and then as the Gaddafi regime lost power and a new regime came in, they started gutting those sanctions by issuing broad general licenses. But unlike the Cuba sanctions, they never wrote those general licenses into the regulations, and that essentially means that OFAC can rescind those licenses without any sort of administrative review, and the strong sanctions can come back in at any time. With Burma, they took a more gradual approach, initially implementing some of these general licenses, and then gradually, as bilateral relations between the United States and Cuba improved and the human rights situation became better there, they started writing those general licenses into the regulations. Well, what they did with Cuba was very different. The administration immediately jumped into writing the new general licenses and other authorizations into the regulations without there being sort of any phase-in period. And they're able to do that because the president exercises broad discretion under one of the 2 statutes that govern the Cuba sanctions. It's called the Trading with the Enemy Act, and it goes all the way back to World War I. The president essentially exercised the discretion that he has under the Trading with the Enemy Act. He does not have anywhere near as much discretion under the 1996 Helms-Burton Act. So to the extent that large aspects of the Cuba embargo still remain in place, as Greg mentioned earlier, it's because of the 1996 Helms-Burton Act and because congressional authorization is necessary in order to unwind those parts of the sanctions. Long story short, even if bilateral relations go well, negotiations between the United States and Cuba go well in the coming months, even if we see a Cuban embassy open here in Washington, D.C., we're unlikely to see any major changes in the Cuba sanctions in the near term unless Congress gets on board. With that in mind, I'd like to turn over to Lauren Valiente right now. She's going to cover the implications of dealing with private enterprise in Cuba, give you a sense of what the Cuban environment looks like now that we've covered the opportunities and risks on the U.S. side of the ledger.
Thanks, Christopher. Good afternoon, everyone. So I wanted to spend my time with you to shift our focus from the U.S. side of the equation to the Cuba side of the equation and talk a little bit about the state of private enterprise in Cuba. The reason I want to focus on this topic is because in order to really understand the opportunities that are going to be available to you under these new regulations, you have to understand not only what's allowed under U.S. law, but also what's going to be allowed under Cuban law. So I want to focus on private enterprise because most of the new U.S. regulations are limited to trade with private Cuban entrepreneurs or private farmers. So it's really important to understand what's going on with private enterprise in Cuba. So I want to focus on the state of the private enterprise and also on Cuba's current attitude with allowing foreigners to directly trade with private citizens. So as a bit of background, the good news is that private enterprise and the private sector in Cuba is slowly growing. Since Raul Castro came to power, the Cuban government has slowly begun to expand the private sector in Cuba. So currently what happens is the Cuban government issues a list of the types of activities and professions that are authorized as private enterprises. And currently there's about 200 of these activities or professions on that list. The most popular of which include restaurants and nightclubs, bed and breakfast, transportation services, and construction. So how does the Cuban government regulate these private entrepreneurs? They do it through licenses. So if a Cuban citizen wants to run their own business, they have to get, first of all, it has to be a business that's on the government's list of approved activities, and second, they have to get a license from the government. So these private citizens that have licenses from the Cuban government to operate their own businesses are called cuentapropistas. And currently there are about 480,000 legally registered cuentapropistas operating in Cuba. So that's your market base. If you're looking to take advantage of these new U.S. regulations that are targeted to private Cuban entrepreneurs, this is your market base. And one important point to understand, too, is that these licenses are only issued to individuals. There are no private companies in Cuba, so you're dealing with private individuals. And some of these private businesses, especially the restaurants and nightclubs, are being successful, and they are thriving. But for the most part, you're dealing with mom and pop type shops, family run businesses. And as of today, I think everyone would agree that a middle class is slowly emerging in Cuba. We are seeing more purchasing power among those that own their own businesses, and that is changing from what has happened historically, where for a long time the average salary in Cuba was about $20 a month, but now with this slowly emerging middle class, you're seeing a group of Cuban citizens with much more purchasing power than you'd seen historically. And so, as I said, some of these businesses are thriving and they're succeeding. Others are having trouble and others fail. So I wanted to go through the specific obstacles that these private enterprises face in Cuba, the first of which are fees and taxes. So in order to obtain the license from the government in the first place and to maintain it, the Cuban citizens have to pay a monthly license fee, which is expensive. On top of that, many of these businesses are taxed at 50% of their revenue. So that in itself is a hurdle. But by far the biggest hurdle that these private enterprises face is that they lack any access to wholesale markets. So for the most part, they have to purchase products in retail value, and so their ability to sell those products for profit is extremely limited. Thirdly, you have a scarcity of inputs, and what I mean by that is, For example, if you've got an air conditioning repairman, it's going to be hard for them to find the parts that they need to do their work. So any type of goods that the private entrepreneur needs to run their business, sometimes they're not very easy to find. Then the fourth point is uncertainty over continued authorization. So as I said, you've got this list of authorized activities, but the authorization can be pulled at a moment's notice. Not too long ago, the Cuban government authorized retailers to sell clothing that was imported from foreign countries. But then I think about a year ago, at a moment's notice, that activity was no longer authorized. So whether they can continue to engage in that activity as a private citizen is always in question. Next is weak purchasing power, and we're seeing that change as the middle class grows and as these private businesses succeed. But historically, because the average citizen made about $20 a month, their ability to purchase goods and services from these private entrepreneurs was limited. And lastly, scarcity of commercial rental space. Now, the biggest obstacle by far for U.S. citizens in their ability to take advantage of these new regulations and to trade with Cuba is that right now direct trade between private citizens and foreigners are severely restricted in Cuba. And any type of direct trade with private entrepreneurs is going to require significant reform by the Cuban government. What the U.S. has done essentially with these new regulations is put the ball in Cuba's court. So they've said we're going to let Cuban citizens trade with, or we're going to let U.S. citizens trade with private Cubans, and Cuba, it's up to you now to let that happen, because as of now, Cuba's foreign investment law prohibits foreigners from partnering with private enterprise, and private sector entrepreneurs cannot independently import or export products without a license. One of the few categories of private citizens that can export that have been given this license are artists. Cuban artists can export their art to foreigners. So now the big question is, what's Cuba going to do? And so everybody's waiting to see whether Cuba is going to relax those restrictions and allow private Cuban citizens to trade with foreigners. The biggest obstacle there, I think the biggest sticking point may be that Cuba is still on the list of state sponsors of terrorism. And Cuba, especially in the recent press, the Cuban officials have repeatedly pointed to that as a sticking point in negotiations. Now, it looks like there are Cuban officials meeting, I think, with the administration in Washington tomorrow, and there's hope that the president will announce his intent to remove Cuba from that list before the big summit in April, before the Summit of the Americas in Panama. The good thing is that the president does not need congressional approval to make that decision. Once he makes it, I believe there's a 45-day waiting period until it takes effect. I think that's if that occurs, the hope is that Cuba will then come to the table and will facilitate some of these transactions with private citizens. So it's right now it's a bit of a waiting game, but there's hope. A few other obstacles to trade. They're high. The U.S. on the U.S. side, the U.S. imposes high import duties on goods imported from Cuba. Then in shipping, there's currently no direct mail service between the U.S. and Cuba. American companies cannot finance exports to Cuba. And Cuba's dual currency system. So for those of you who don't know, Cuba has this dual currency system. So most tourism operates under the convertible peso, which is tied, the value of the convertible peso is tied to the U.S. dollar. Now, the Cuban citizens are paid under the traditional peso, which is worth about 4 cents. And so this dual currency system has caused quite a bit of a headache and problems in Cuba. Cuba announced back in October 2013 that they were planning to do away with that dual currency system and unify the currency. but it looks like that has still yet to occur. They're working on it, but it hasn't quite happened yet. So where are we going? What's the future of private enterprise in Cuba? As I said, I think there's a lot of optimism that Cuba does want to engage and that they will take steps to expand private enterprise and to facilitate trade between the private sector and foreigners. I think once you see Cuba removed from the list of state-sponsored terrorism, hopefully we will see more movement on the Cuba side. I think the outlook is optimistic. Although I think it's important to remember that any change on the Cuba side is going to occur slowly and it's going to be tightly controlled. They're very much still a socialist system. We're not going to see them embracing capitalism. They will want to keep control of that system. So they will be very careful in easing and expanding private business. Okay, and with that, I think Jackie has an announcement before we move back to Greg.
Yes, thank you, Lauren. At this time, I'm going to read the CLE code for this program. If you're in need of CLE credit today, please enter this 4-digit code into the poll question on the screen after it is announced and press the Submit button. The code is YSLY. That's Y as in Yankee, S as in Sierra, L as in Lima, and Y as in Yankee. Again, that's YSLY. If you are seeking CLE credit for this session, please complete this polling question. And as a reminder, those seeking Kansas, New York, and New Jersey CLE, you will need to please fill out the attorney affirmation form. Thank you. Greg?
Okay, thank you, Jackie. The next thing we wanted to talk about is regulatory risk management. This is an issue that comes up for a lot of companies that operate abroad, not just with regard to the OFAC sanctions, but with regard to all the areas where the U.S. government is especially aggressive. And we end up writing a couple of dozen compliance policies every year for companies that are operating abroad, and things like the rapidly changing OFAC world, where you not only see changes to the Cuba sanctions, but also saw new Russia sanctions come about and various changes to the Iran sanctions, underscore just how important it is for people to be on top of their compliance if you're dealing with selling abroad or operating abroad. So we thought we would start with talking a little bit about sanctions compliance and putting it in kind of a broader context, because what we recommend is that companies take an integrated approach to compliance. What you need to do when you're operating abroad is recognize there's a whole host of new laws that govern your operations abroad and your sales abroad, and you need to look at your entire risk profile, including the OFAC sanctions. Some of the areas that companies will typically look at are not only the OFAC sanctions, but also the impact of the export controls on their sales, the Foreign Corrupt Practices Act, international antitrust and fair competition, anti-money laundering, and anti-boycott. And in a number of these areas, we've seen the U.S. government is being extremely aggressive, and there's often a link between them. For example, up until now, there really haven't been any Foreign Corrupt Practice Act activities, any enforcement action with regard to Cuba, because there really hasn't been any trade with the Cuban regime. But one would expect that the Department of Justice is going to be very vigilant and looking for people as they look to move into the market to see, are people engaged in any bribery of government officials or bribery of people who work for any state-owned entities that are over there. So one would expect to see that there's going to be more FCPA enforcement action with regard to Cuba, just as there is with regard to many other countries in Latin America where there's been frequent bribery requests. So all this is to underscore that when you're thinking about expanding into a new market, one where there's a lot of uncertainty in Cuba, you need to be thinking broadly about the regulatory risk profile and the risk creating while you're moving abroad. Now, some of the key issues that people tend not to think about is not only the need to have a compliance policy governing things like the OFAC sanctions or the FCPA, but also how you need to have like a compliance infrastructure, to have people abroad who are going to help administer this. You need to have training for people who are going to be dealing with these countries or who are operating abroad. A lot of companies will have a compliance hotline, and it's especially important that you have procedures in place, whether by contract or by other means by which you can control the actions of agents or third parties. Because the view of the U.S. government is regardless of whether it's FCPA or OFAC sanctions or export controls, if you have another company that's operating on your behalf, you're responsible, in effect, for their actions. And if they're accomplishing your business in a way that violates U.S. law, they're likely not only to go after the agent, but they may go after you as a company that was engaged in the transaction as well. So some of the key things to look at is for companies that are operating abroad is to assess your risk profile and see where the key risk is based on how and where you are doing business. Some of the key risk areas that need to be considered are how often do you operate in countries that have a relatively lax view of the rule of law? Do you operate through third parties quite a bit? Are you exposed to potential whistleblowers, such as from disgruntled employees or people who might feel that they have a grudge against the company or maybe even a competitor? Are you engaged in adequate screening of your transactions, such that you're looking for the SDNs that Christopher mentioned? And then look at the areas of the company where you're most likely to have issues come up with regard to export controls or OFAC sanctions or dealings with other companies, such as the people who are engaged in landing new business in your contracting department, people who are engaged in shipping and logistics, and people who are engaged in potentially vetting mergers and acquisitions as you move abroad. Some of the key OFAC risk factors in particular are ones that you need to look into carefully, including if you're a U.S. company who has foreign subsidiaries, are they doing business in sanctioned countries or with sanctioned countries, perhaps under the assumption that they're outside the reach of U.S. law? Then that assumption needs to be checked very carefully. Do you operate in areas that are known diversion points? Traditionally, sales to Mexico, for example, were often diverted to Cuba. It was fairly common for that to happen, and now increasingly to Iran. So that's a concern as well, even though there's no restrictions on doing business with Mexico. And I should point out, too, if you are interested in seeing what a risk assessment questionnaire would look like, you can just contact me at ghusisian at Foley.com as indicated at the end of the slide, because we have tailored risk assessment questionnaires for different industries and for companies doing business within Latin America that can help you identify what are the key risk elements for your way of doing business in this area of the world. Some of the other things to focus on that people overlooked, oftentimes people have a very U.S.-centric view of compliance. They write things in complicated language, they don't use plain English, or they don't translate it into foreign languages where people operate, or they have a reporting hotline that's only open during the times of day when the U.S. company is doing business. None of these things work if you're a multinational company. Instead, what you want to do is to make the policy as broad and as accessible as possible. It's often a good idea, too, if you're operating abroad, to bring your local management into play so that they can give the compliance message some credibility, because otherwise it tends to be viewed as being a legal initiative that doesn't really have any credence with other people. Now, with regard to OFAC compliance in particular, some of the best practices, you're going to want to focus not just on the Cuban sanctions, but the full range of sanctions that OFAC maintains. There's more than 24 sanctions programs that are in place, and the Cuba sanctions are only one of them. There's also a variety of sanctions aimed at Israel, at Iran. There's sanctions that are aimed at dealings with the Syrian government and the North Korea government. There's ones aimed at people who are engaged in terrorism or proliferation of weapons of mass destruction or narcotics. There's even new sanctions in place against certain persons in Russia and certain companies. All these areas need to be evaluated and brought into your OFAC compliance system so that you can determine that you are protected against the full range of potential OFAC activity and enforcement actions that could impact your company. One thing that is essential if you have a good OFAC system is that you have a good screening system. The Department of Commerce and the Department of Treasury, OFAC, may have lists of the bad guys, especially designated nationals and especially designated terrorists and people like that, who are into a combined list. In fact, if you go onto Google and you type in list to check, the very first entry that comes up is going to be the OFAC list. And the OFAC search site, which used to be fairly pathetic, has gotten to be very good. They have a new fuzzy logic tool which will allow you to systematize your searches. It's not as good as some of the third-party providers like MK Denial or Export Web, which allow you to run your entire customer base through at one time and to keep an audit trail, but it does allow for a quick check if you've got a handful of people and you want to check them out and see if they're on the list. Because if you deal with someone who is on the list, you really have no defense, because OFAC is going to say, look, we published this list for a reason, and if you had dealings with them, the question is going to be how much the penalty should be rather than should there be a penalty at all. One thing we've seen from the Cuba sanctions is it is very necessary to regularly update your compliance program because these laws are changing all the time. Nobody thought a year ago that we were going to have sanctions against Russia. Those seemed like they were a relic of the Cold War past, but yet we have them today. It also really wasn't on the horizon that people were thinking that the Cuba sanctions, which had been around for a half century, were going to significantly change. It seemed like those were going to be static. These regulations change all the time, and if the U.S. government is changing the ground rules, then your compliance systems and internal controls need to change at the same time. Some of the other best practices is you need to have internal controls. It's not enough just to have an OFAC compliance policy in place. You need to have very specific rules. Who is going to be the person who's running the screening against the OFAC SDN list? Who's responsible for resolving any potential matches and seeing if they are a false positive or if it's really something of concern? Who's going to be the person who's going to follow up if there's red flags that indicate that something is suspicious about a transaction and it might be diverted? Those are very important to have, and it needs to be done in a way where it systematizes to who and what department is going to be in charge of that area. Another thing the U.S. government expects as part of its concept of know your customer and have adequate controls for dealing with your international sales is they expect that you're occasionally going to have audits or compliance checkups to see whether your compliance program is not only well written, but whether it's being well followed and is working within the field. You can't let your compliance program run on autopilot. It has to be constantly evaluated and improved based on your experience in dealing with issues as they arise. Now, this is all very much going to be true with regard to the Cuba sanctions as well. If you're thinking of dealing with Cuba, as Christopher said, this is not a free-for-all where you can just go in and say, okay, it's okay for us to go in and pick up new business. Our expectation is going to be that OFAC is going to be very strict on the areas where there has not been easing. In other words, just because they've opened up the telecommunications market doesn't mean that they've opened up other markets. Just because they're allowing you to deal with certain small businesses doesn't mean that they're going to look the other way if it appears that there's a strong government connection between the entity with which you're dealing and leading back to the Cuban government. They're going to be very alert for that, and the fact that easing is going on doesn't mean there's going to be an easing of the enforcement at OFAC. We expect that they're going to say for anything that is beyond the easing, they're still going to come in and potentially put in these very large penalties that we've seen with regard to the Iranian sanctions and with regard to the Cuban sanctions, actually, prior to the easing. So OFAC enforcement is not going away. Some of the areas that we think OFAC is going to have special consideration and going to be looking out at bringing potentially large enforcement actions are people who exceed the limitations on the scope of permissible business. particularly if it appears they're ignoring red flags that Cuban government officials or the Cuban government is somehow involved. If this is viewed as being a conduit by which the Cuban government is taking part of the transaction or is getting kickbacks or is any way involved, they're going to be very vigilant about that, because that's going to be exactly what some people in Congress are going to say is a problem with easing the sanctions. So I would expect that they're going to be very vigilant and looking at that as well. So any kind of business that's conducted needs to have substantial due diligence into the people who are going to be involved, both up front and behind the scenes of the transaction. The limitations on travel, we don't know how vigilant OFAC is going to be on them. They have said that there's not going to be any kind of general tourism and that they're going to be looking at permissible categories of travel. As to whether they're going to be vigilant about this or whether they're going to just see how things develop, it's not clear at this point. The best assumption is that if you're going through and you don't have a valid reason why you can say you fall within the categories that are permitted, then you should be very careful, because you're putting yourself at potential risk of OFAC enforcement action. Same thing with regard to anything that creates a property interest that goes beyond the scope of the areas that have been delineated by OFAC. It has long been OFAC's position, whether under the Cuban sanctions or otherwise, that setting up even prospective future business creates a property interest within the sanctioned country. Now, what does this mean? It means that if you enter into what seems to be a fine contract to say, in the event that the Cuba sanctions are lifted, here's the business arrangement that we will have, you can't argue and say, well, it can't be a problem because it's contingent on OFAC lifting the sanctions. OFAC would say, no, that's not true. You've created a present property interest in a future transaction, and that violates the sanctions. So that's something that, for people who aren't in this area, is not at all intuitive. Finally, with regard to the importations of personal goods, it's not clear at this point how Customs is going to be looking at that. I expect that they are going to be told to look very carefully and make certain that people aren't using this as a way to take their personal remittances and to use this as a way to get around the sanctions, and that they're going to be looking carefully at the dealings in the personal goods from people who are traveling to and fro. Finally, the compliance program is complicated in this area because, as Christopher talked about, first of all, we don't know what Congress is going to do. Are they going to sit tight with the existing easing of the sanctions but say don't go farther? Are they going to try to roll them back? Are they going to authorize maybe even certain kinds of expanded travel and trade with Cuba? You don't know, but you do need to monitor it if you're doing business with Cuba so that you have an up-to-date compliance program. Same thing with regard to the enforcement posture. OFAC hasn't designated very many people under the Cuba sanctions because they never needed to. It was forbidden to deal with any Cuban persons who are ordinarily resident there. It may be that now that the sanctions are being eased and there's more trade that's going on with Cuba, that they're going to start designating more people as SDNs, in which case the premium on doing good screening is going to become much greater. And then lastly, as I talked about, don't forget about other laws. We would expect to see more FCPA enforcement actions coming about in Cuba. Anti-money laundering, if that appears that is going to be an area where there's now more money going through Cuba and it's being used to hide criminal activity or something like that, or dealings with the Castro regime, then that kind of issue could come up as well. So at that, I will, the slide is just to remind you that it's going to be available for download, our International Compliance Guide, and God forbid if anyone needs it, a guide on how to conduct an internal investigation if you have something that is going wrong. But finally, if you email me, then we also have a risk assessment toolkit which can be tailored to your company and which could help you assess the risk for all your international compliance areas, including for the Foreign Corrupt Practices Act, export control, OFAC sanctions, anti-boycott, and other areas.
Thank you, Greg. This is Francisco again with a proper internet connection this time. We're running out of time, but we received a number of questions from the participants, so we're going to run over them by a couple of minutes and try to address several questions which have been actually asked repeatedly by different participants. Clearly, there's going to be a lot more questions. We actually plan on doing subsequent webinars which are more targeted. So, for example, our clients who are participating, friends and clients who are participating, they're from the financial services space or from the insurance space. We're going to be doing targeted to those areas as well as agriculture. So there will be other opportunities to get more in the weeds specific to your industry. We're trying to touch on the broader points that impact across industries. But having said that, I will ask Christopher to answer a couple of the questions that have been coming up. One of them is, can we buy real property in Cuba? And if so, does it make a difference if it's property from the government or otherwise?
Okay. Thank you, Francisco. The short answer to that question under U.S. law is no. The Helms-Burton Act still prohibits this sort of activity. This is outside the realm of what the Obama administration has authorized, and it is well in the realm of what Congress would need to approve. There's also the question of whether the Cuban government would authorize U.S. persons to purchase property in Cuba, and that's a completely different question and would get into the area that Lauren was covering earlier. At present, the answer there is probably no as well.
And Christopher, another participant has asked, is there an indication that U.S. insurers will soon be recognized by Cuba such that U.S. travel health insurance can insure customers traveling to Cuba? Could you speak to that, please?
Sure. Well, look, there's two or three different ways to look at that issue. The first is if you are issuing international private medical insurance, IPMI-type products, you can issue them now for coverage in Cuba, and a person holding that kind of policy can receive medical treatment in Cuba and be reimbursed for it, including a reimbursement in the United States and payments to the providers in Cuba that provided those medical services. That's our current understanding of the law. We'd need to have a little more detail about the particular nature of the policy before we could, sign off and give an official legal opinion on it. But as a general rule, international private medical insurance is going to be authorized from a U.S. side. Now, whether the Cuban government decides to recognize officially or unofficially U.S. insurance providers is a different question. That gets to the question of how you can onshore the provision of insurance services inside Cuba itself. For the moment, U.S. law, the easing of the sanctions, doesn't authorize that kind of onshoring, but it does authorize travel-related medical insurance of the kind I described earlier.
Okay. We're going to do 2 more minutes and then 2 more minutes. If you could please address, a friend is asking us, for the sale of agricultural machines authorized by the new provision, must they be sold directly to the private farmer, or could they be sold to a reseller agent/dealer located in Cuba?
Okay. We need to know more about the particulars of that particular transaction in order to opine on it. As a general rule, as long as the ultimate end user of that particular equipment is not going to be a governmental entity and is not an SDN, a blacklisted person, it would probably be okay. But again, that gets into the realm where the devil is in the details, and it's best to reach out to us individually or email our group. You have our contact information. That's an area where we can get more information and then give you more specific guidance.
Okay. There's a question that's come up several times, which is exceptions for entrepreneurs. Specifically, for example, one of the questions says household products like kitchen appliances and hair dryers and similar products, would they qualify under exception if they're sold to entrepreneurs? So if you could speak to just exceptions to entrepreneurs and then to the extent possible to these type of household products.
Sure. As long as it's being sold to, the household products are being sold to a private person for use in private enterprise, the license exception SCP, support for the Cuban people, is very broad. It's machines, it's equipment, it's supplies, it's instruments. So those kinds of household products could very easily be fit under that license exception. Now, that being said, we need to have much more detail about who exactly the entrepreneur is, what exactly the products are, and how the whole deal would go together before we could say whether it was completely authorized or not completely authorized. But as a general rule, as long as those instruments or those products are being used by private sector people for private sector purposes, license exception SCP is designed to facilitate those kinds of exports.
Okay, and we have time for one last one. Everyone who answered a question online, who asked a question online, we will be happy to address them individually, to respond to them individually. But we'll do one last one, which has been asked repeatedly, which speaks to the U.S. being able to finance, U.S. parties being able to finance Cuban exports. So, Chris, if you could speak to that one, and that will be the last question we'll answer on today's webinar, but we will answer all the others in writing over the coming days.
Sure. Francisco, that's another area where really we need more information about the nature of the financing. If you're talking about U.S. government or U.S. Export-Import Bank-backed financing, that's not on the table right now. But if you're talking about private financing for the kinds of exports, telecommunications, agricultural equipment, things like that, that are now authorized under the sanctions, there are some very strong arguments to be made that that kind of activity is ordinarily incident to those sort of exports. Again, we'd need to know more details about the specifics. Great opportunity. You see our contact information. Don't hesitate to call or email us. We're more than happy to help. But in some instances, you could finance those exports, just not with the kind of support that we see for large-scale exports through the U.S. Import-Export Bank.
Okay, thank you, Christopher. So we thank everyone for participating. These are exciting times, many opportunities ahead. Earlier today we were commenting before the webinar. Today's trade with Cuba accounts for approximately $400 million a year, mostly in food, and it's anticipated it could go up as high as $20 billion per year. So clearly, over the coming years, there's a lot of activity that will take place. This was just a beginning explanation. We look forward to continued dialogue with all of you. We thank you again for participating. As Jackie mentioned, the copy of the PowerPoint will be available in the next couple of days, and you could access it by going to Foley.com, as well as an audio file of today's webinar. So thank you, everyone, for participating. Thank you to the presenters, and have a great day.